Is this lawsuit a lost cause or just the beginning of a serious case?
The Dan York State of Mind program is brought to you in part by Lookout Rhode Island and Takeo Comfort Solutions.
Good evening, good Monday to you. Oh, a summer day almost. It's still formally summer, we got a week left. Sports gaming, it's been a really interesting ride, right? So now you can do it on your phone if you can get verified. That's a story for another day. This weekend I actually tried to get on the sports bet app, and I'm still working with them, let's put it that way. But for the most part, it seems to have launched fairly smoothly, and thousands of people have signed up for their ability to be able to just make a decision from wherever they are inside Rhode Island to bet a football game, a baseball game, or whatever. But there's serious ramifications to the underbelly and the constitutional process involved in this kind of gaming. And we've had these conversations before, and my two guests this evening have already been on the program when they first launched their litigation against the state of Rhode Island for the lack of process, constitutional process, translation, the vote. And so there's been some twists and turns to this case, and we're going to start from the back, meaning from the beginning, so that we can bring you up to some unique moves that these two lawyers have pursued to make their case. So here's the headline that began all of this conversation. It's kind of a recap. This is when it first started. The former GOP chairman, Brandon Bell, has become co-counsel with lawyer Joe Larisa. Both of these guys are standout lawyers, and Joe has vast experience, at least more than a decade ago, almost 2 decades ago now, in a gaming case where he was right. He was right on Harrah's, and if you remember, the attempt for that tribal casino project to work. Gentlemen, thank you for revisiting this with me. You just ended up in court. The case has been moving along, but before we get to that, that's kind of stage 2 and 3. There have been a couple of different chapters in this whole thing. First, Joe, you've been claiming from the onset that the decision to have sports gaming in general, forget the mobile app process, was unconstitutional. Tell me why that is in your mind.
Well, as we discussed before, and we're back again, doing it again. Article 6, Section 22 of the Constitution, which is the supreme law of the land, says any expansion in types or particular forms of gambling have to be approved by the voters. The voters had on the ballot table games. They also had on the ballot video lottery terminals. They've never had on the ballot anything resembling sports betting, which is a game of skill. And players play, and the odds are determined by who wins outside the casino, as opposed to table games and video lottery terminals where it's built in inherently into the machine. And the voters are entitled to vote on it under the plain language of the Rhode Island Constitution.
And the folks who disagree with you, meaning the entire state government and its lawyers and its vendors, suggest that the last time we approved statewide and in Lincoln, and then in Tiverton, I guess, gaming in general, meaning casino-type gaming, that there was a category that was claimed, cited, and in that reference to the category, it's and any other type of gaming, and any other type of gaming. And they suggest that and any other type of gaming covers sports betting, that when we voted back then, we more or less carte blanched anything that a casino could come up with to take our gambling money.
Now, you're much better than them, Dan, because they're not even claiming that. The and any other type of gaming and anything a casino could come up with, I still think loses, but would make a better case than they're making. It doesn't say that. On the ballot was something called casino gaming. And casino gaming was defined as those types of games considered Class 3 gaming in 25 U.S.C. 2708 subsection 3. But that statutory section wasn't anywhere in the voter information
by the way, do you think the guy's been working the case for a while? Any other algorithms
we know all the numbers by now.
Or calculus you want to bring to the table?
You know
here?
what it needed to say? Sports betting. But you know that statute I just referenced that you're making fun of me for? If somebody went to look for that statute, they still wouldn't find sports gambling in there. It's not there. It's nowhere.
It was illegal at the time it was written.
And it was illegal at the time. So
Across the country.
Across
And
the country.
Until 2018, except
Right.
one jurisdiction.
So Brandon's good on the, well, you're good on everything, but and including data. Woo! If I just give you a random case, could you give me the code?
He should argue the plaintiff's
This
case.
is-
Anything played anywhere
There's
in a casino.
there's a little
Matt,
bit
that's
of
not
Rain
easy.
Man going on here, it seems to me. It's just so funny.
He doesn't count cards, so
Doesn't
we
count.
tried that.
Well, that would be ironic.
And I can't spell
Wouldn't
backwards.
it? I mean,
yes.
that would be ironic if you can count cards. Get it, gaming. Good. The politics of this are interesting, Brandon, because as we follow the General Assembly and see the chronology of this case, everybody was kind of hot to trot on the Supreme Court deciding a case for New Jersey to pass sports betting there. Of course, it was legal in Vegas, but they were carved out.
The United States Supreme Court, I just want to be clear.
United States Supreme Court. And so, with most of the pundits in the legal world saying this is going to tip for New Jersey, which means it's going to tip for the country, the General Assembly got their whistles wet over this entire thing and began to plan for it. The timing of this was such that they could have, during our last General Assembly session in 18, they could have asked for a question on the ballot in the fall as they were getting up with the system and the technology to implement this thing. Instead, they just decided that we didn't need...
Or an advisory opinion, Dan. They could have asked for that.
Or could
too.
have asked for an advisory opinion.
On the Supreme Court.
And you really think if they have done an advisory opinion, they would have said, yeah, they need to vote on it. It would have been pretty... That's what you're
my
saying.
clear opinion, yes.
But they could have done that anyway to double protect themselves. Instead, they were so excited about hitting Labor Day in the first football game, and then ironically, guess what? They didn't make the deadline anyway because the technology wasn't ready. It wasn't until Thanksgiving plus that they had any games available for betting.
Yep.
What a blown opportunity to get you two guys out of their hair, right? Potentially. Yes?
They didn't think that we were going to find a plaintiff, I guess, or they didn't think that we were looking, who knows? I mean, I don't know what they were thinking. But Gina Raimondo, when she proposed her budget in January of 18, knowing that SCOTUS was going to come down with this decision, and everybody thinking that, of course, it was going to be overturned, the ban on sports gaming nationally, she included it in the budget. She put $23 million into the budget, for this, because we rely so heavily on it.
And missed the broad side of the barn because the timing on it was off anyway. And in fact, the gaming projections have scaled down since. So here we are. That's chapter one of all this. So when we come back, I'm going to take a break here. When we come back, we'll tell you, Joe was kind of issue and plaintiff shopping. And that's where Brandon came in, did a little networking. And they almost got to the finish line a week ago. But now there's something new. It's all coming. Stay with us. So this is kind of stage two. A lawsuit was brought. What we didn't discuss in segment one was how the case finally came to bear. But I want to kind of tease how we're going with this conversation. So Brandon Bell and Joe Larisa are co-counsels in this plaintiff case against the state of Rhode Island for not asking us a question, should we have legalized sports betting, meaning in a referendum. So you found a plaintiff. You went shopping for a plaintiff, and you found this guy, Dan Harrop, who is a former candidate for mayor in Providence years ago, civic-minded guy. You found him because he was able to help finance the discount legal price of doing this. Because you've always said this is about advocacy, not necessarily about profit for you.
Definitely isn't about profit.
Right, okay.
Public interest lawsuit.
And I would just correct that. He actually found us.
He found you?
Yes. So you may recall, we were on the show back in March. We talked about.
Oh, and that helped you. We helped you recruit them.
I say because of state of mind,
There you go.
he contacted me and said, what the heck? This is not a good government thing to avoid the Constitution of Rhode Island.
Okay.
The supreme law of the land.
So you needed a player. You took that player to the court, and you made your arguments. And Joe, there were two stages to this case. One is a hoop you have to go through. The other would be arguing the merits.
Right.
The hoop is the plaintiff of standing, meaning are they allowed to file this lawsuit? And you lost with Judge Brian Stern on this last week. What happened?
Well, that's round one, the standing round. You have to get through standing in order to reach the merits. Last week, the judge decided that Dan Harrop, on the facts pled in the complaint, didn't have sufficient standing in order to sue, and also didn't find that the separate element of standing, which actually excuses the first element called substantial interest standing to raise this public issue, wasn't met. So when that happens, the plaintiff gets to amend their complaint to allege the facts that the judge found relevant if you have them, or you can find a new plaintiff.
The
to get there.
headlines were judge dismisses lawsuit, and if you just read the headline, you'd think that the conversation was over.
Sure.
You came out of the courtroom talking to the press, suggesting that you'd be back, not from some wise guy point of view. I mean, you were saying, listen, this is. Well, you were almost instructed by the judge, seems to me. Based on what I've read now, it seems to me that Judge Stern was saying, look, I don't think he's got standing. Maybe you want to talk to Tiverton. The town of Tiverton is engaged in this case because it wrote a letter to the court asking for an accelerated decision because they have housed the casino, they have sports gaming, and they have $100,000 in money that they use for their budget from the gaming. They're trying to get a fix as to whether that money's real for long term and whatever the politics. So they became a party to the case, but they don't have. They
didn't technically become a party to the case. They just sent in a position paper. They didn't say we're a plaintiff.
But they made arguments that were interesting as they.
Yes.
They asked to come into the party and say, listen, we have an opinion, and the opinion is, could you go fast? They made good arguments.
Yeah, they made a great argument that that it would be in the best interests of the town of Tiverton as a host community for one of these sports gaming venues to be able to have a decision sooner rather than later.
But they didn't take a position. Yet now they're deciding whether they're going to decide about taking a position. So
I'd say they took a position, but the meaning that that actually was a position statement. They said, look, we believe that standing should, be that the standing issue, that Tiverton wants a decision, so therefore they have standing. By the de facto standing by the fact that they are a host community, and decide on the merits, please. But we're not going to take a position on the merits at this time.
Right. But now they're deciding whether or not, A, they want to ask for formal standing, meaning become a plaintiff, or they say they're going to decide. I mean, their casino vote was by the hair of the chinny chin chin.
51-49, I think, yeah.
Less.
Okay.
Less. So you'd think there'd be some compelling arguments going on in town about this whole thing, unless they all just feel like it's water under the bridge and whatever.
I think part of the problem, and again, I don't know how it's advertised, I understand it's on for a hearing soon, and part of the problem is that I think most residents don't understand probably what we're actually looking to do here. We're not looking to close the casino. And again, they might look at it and say, hey, they've been open for a year, the casino, and we're thereabouts, maybe a little over a year, and they're a good corporate citizen, and we don't want them to be closed. No. We're looking at the constitutionality of whether or not you get not just one vote statewide, but another vote because you're a host community, which is what the Constitution calls for.
And this can be a little haphazard, this conversation, because we're all three very familiar with it, but you've never taken a formal position on whether you support sports gaming at all.
Oh, I don't think I would have much of a problem with sports gaming in and of itself. The online part of it bothers me a bit because now
it certainly has exacerbated I think the need for clarification. Joe, you've kind of reserved judgment as well in terms of whether you would vote yes or no on sports gaming.
Right, and Dan, for the people of Tiverton, to make this real simple, what we're fighting for is their right to veto a new form of gaming, sports betting, or to confirm the bill and sign it. That's their right under the Constitution. And as you know, through the years, the people of Newport have zealously enforced that right to either confirm or veto. The whole rest of the state can go for it, but if the host community says veto, as they almost did with the casino, it's vetoed. If the host community says let's do it, then they do it. And all we're fighting for here is with sports betting, online sports betting, and the virtual casino, Tiverton weigh in.
So,
and Newport did that with table games.
So Judge Stern said, hey, listen, this guy, Harrop, doesn't necessarily have standing. Maybe he was just trying to load up, because there's no doubt that whoever loses this case will appeal it to the Supreme Court. And so you want it seems to me, from a layman's analysis point of view, that Judge Stern is trying to dot his I's, cross his T's, not make a decision on the merits of this thing without really loading up the standing situation, so he's not turned over. up at the Supreme Court. So he gave you a little bit of a hint that Tiverton might be a better place to shop for standing, and then he suggested that Mr. Harrop had no more pain than the average voter. Harm, thank you, in this whole thing. But if you found a guy that lost a bunch of dough in sports gaming, when we come back, we're going to talk about what I still don't understand that, to be honest, but guess what? All of a sudden, Mr. Harrop remembers something. We'll be right back. So this is phase 3 or 4 of the case. A plaintiff lost money on the Patriots, sues state again to stop sports gaming. Actually, did I see that part about it? Maybe I didn't read that version. I couldn't figure out what he played the game. Did he bet the Super Bowl? Well, no, seriously, what did he bet? Do you know what he bet?
It was a bet in December.
In December of last year.
Yeah.
They lost 2 games in December.
So judge says, so he bet legally. He bet at the casino.
Yes.
Oh, yeah,
yes.
bookie,
Wait a minute. I didn't see that in the judge's recommendation. Maybe you
That wouldn't help
go
us.
find a good bookie. Find a good bookie. Maybe no. But you never mentioned that in your original suit. In other words, Mr. Harrop, who is the plaintiff for these 2 final lawyers, did he ever mention to you that he had actually participated in the sports gaming?
We amended our complaint after Judge Stern ruled.
No, maybe,
and
but
find
prior
that
to
out.
Judge Stern saying maybe you want to go find a loser, like a gambling loser.
We didn't
know.
look to find a gambling loser until Judge Stern ruled and said you may want to find a gambling
But what's
loser.
interesting to me is that he called you to say, yeah, we should be able to vote on this, but he had, based on shows that we had done here in 2019, but he says in 2018 in December he lost money on bets at Twin Rivers. So he too is not conceptually opposed to gaming, seems to me. He has the same perspective as I do, which is I don't have a problem with sports betting. I'd vote yes.
Dan, this case has
But
nothing to do with sports betting, good or bad.
Right.
Everybody.
But I'm trying to
true,
clarify.
he
Why are you
didn't get to
staring
vote
at
on
me?
it.
Why are you
Right,
looking at me
vote
like
on
I asked the wrong question? He clearly is not. He's not offering a disposition on the nature of sports betting because he's already done it. He sees the constitutional problem that all 3 of us agree we see.
Correct.
All right. So anyway, I think the judge referred to some kind of formidable loss. What is the amount of money that the plaintiff has got to lose in order to have standing? There's got to be some kind of level of loss,
The
right?
Supreme Court has said in a case we cite in our motion to amend, and that's what we did when we found out.
Which Supreme Court?
Rhode Island Supreme
Island.
Court. That the line is not between no injury and substantial injury. It's between injury and no injury.
So
There's
you
no
can lose
substantial-
$5.
Presumably, and I cite a case in there where the plaintiff lost $16.31 and was granted standing.
Gotcha. So how much did he lose?
Doesn't matter.
Literally.
Literally doesn't matter.
Doesn't matter. You don't have to be the what do they call him, a whale?
You don't have to be a whale in Ocean's 11, yes.
But I think
You just
Judge
have to lose money.
Stern is probably going to ask the question.
Well, for the purposes of the motion to dismiss that we've, or the motion to, if they file a motion to dismiss, everything is deemed to be true that's in the complaint. And this is a verified complaint, by the way. He verifies that all the facts are true.
So we're filing a motion to amend. We filed it. The hearing is next Monday. The state will respond to this at some point this week, either not objecting or objecting, and we've got to figure out what the grounds they object on. Right now, the court is not deciding whether Mr. Harrop has standing under the new complaint. The court is deciding whether we have the right to amend our complaint. That's different. We believe we clearly do. We don't know what the state's going to say
Well,
about
how
our right
could
to
you
amend
not?
the
The
complaint.
judge more or less inferred that that maybe I go back and work on this.
Yeah, I mean, motions to amend are very liberally construed. You can amend at trial in some cases.
So your Monday court case is just to determine whether or not an amendment could be made.
Yes, that's what's on.
Well, that's not even worth going to court for. I mean, he more or less suggested go find a better, go find somebody better with standing.
Could it turn into something else? We don't think so, but we don't know what the state is going to file and when they're going to file
So
it.
you don't like to get ahead of yourself, but given that that it will be okay to amend your case and say, oh, by the way, our plaintiff did lose money, Judge, so we're back in the ball game in a standing argument. Would you like to have Tiverton in with you at this point? I mean, they are going through, over the next couple, 3 weeks, some kind of deliberation on their council as to whether or not they want to ask their own folks whether or not they ought to weigh in on this case. Because clearly, with it lingering out there, they're not getting what they want anyway, right? They're looking for an accelerated decision. Do you want Tiverton as a party to this or no?
A plaintiff always wants more parties on their side than not. But that being said,
Don't think you need it.
According to the state, nobody can sue. Attorney General only can sue, and the state made an argument. Last time we were there, Tiverton couldn't sue even if they were formally a plaintiff.
So Attorney General Peter Nerona's big defense here is that he's not even really getting to the merits, right? He's really arguing the standing.
He's doing everything to stop this case from being heard.
On standing.
On standing, that's how they're doing
Because
it.
they really don't want to get into the mix on this thing. Because I think if you can get by the hoop on standing, I think you're going to wrestle into the ground. It's going to be like that. Yeah. And I think they all know it. I do.
Refrain.
But I can't tell you how this guy is very contained. I can't tell you how hard this guy over here is trying to keep his powder dry. Because it's a case, it's a legal case. You don't want to say things to jeopardize and prejudice the case. And all kidding aside, I think the case is important enough not to be a smart aleck about it. The constitutional right of the voters here prevails, is important. You're no gadfly. They think you're half nuts, because you're not playing the establishment game here. You're holding on to a concept that everyone is going, well, whatever. The Pats play this weekend. They blew them out by 45 points. They made $5,000. Oh, shut up. I mean, that's kind of the disposition here. It takes tenacity to keep asking and get the question answered in the court. And I admire you both for doing that. What is the timeline, you think, on the projection of all this? Quick?
Quick.
We think quick.
It would have been quick had we gotten
really
Get
quick.
past standing. The merits of this case are not deep, correct?
Well, here's the interesting point.
I got a minute.
The merits are already fully briefed. It's done. We filed our brief, they filed their brief, we filed our reply brief. Fully briefed, done. So when we get there, there's not going to be 30 days, 40 days, 50 days while everybody briefs it. It's already waiting for oral argument. That's the last step.
And their argument is described as you did in the beginning.
It's casino gaming. Even though at the time the vote was made,
It's not casino
it wasn't
gaming.
casino gaming.
And quickly, 10 seconds. Online only exacerbates this whole thing, right?
Oh, yeah.
Because it changes,
And a virtual casino is next, Dan. It's coming.
Governor
Right.
Moore just said it.
which
Just
means
said
you'll be
it.
able to play blackjack on your phone too. And did we vote on that? All disclosure, I support the gaming issue. Largest non-tax revenue income to the state. But you got to do it the right way. Guys, thank you for the update. Final word when we come back. Look, if this case doesn't get to standing, then something's wrong with the entire system. And I think the state's defense on standing is so aggressive because once standing is decided, I think they got problems. All they had to do is ask for a vote. So there, you could see, well, let's not get ahead of ourselves. Let's just wait to see what the standing thing is. And I'll opine on that at a later broadcast. You have a great evening. Good night.